Okay, so the next question we're going to look at here, picking up where we left off yesterday, where we looked at the players in the federal court system, the litigants, the lawyers, the judges, and the interest groups. Today we want to start looking at the court system itself, how it was set up, how it was arranged, kind of how it exists, right? And so the question here is, how did the framers impact the development of the court system from the very beginning? And first things first, as we've talked about all year, the Constitution is very short, and within its very limited numbers of words, right, there really isn't covered nearly as many things as you might think there would be. In fact, when you look at what does the Constitution have to say about the federal court system, the only specific requirement by the Constitution as far as a federal court system is the Supreme Court itself. But Congress used its discretion and the implied powers kind of created under McCulloch v. Maryland, used discretion to basically establish those lower ranks of courts ranging from district courts to appellate courts, and so on and so forth. And so Congress would slowly add to the federal court system as the country got bigger and population got bigger. The first edition was the Judiciary Act of 1789, which obviously is shortly after the founding of our nation. But this act created what are called courts with original jurisdiction. This seems like this would be like a no duh, like obviously there was some original jurisdiction courts, but it actually took the Judiciary Act to officially do this. Now, what original jurisdiction courts are courts that are tasked with originally hearing the case, right? And so it created courts that would originally try the case. If you were arrested for treason by the federal government, you would go to a court where your trial would be held, where you'd call witnesses and you'd testify, and there'd be a judge and a jury, and basically all of what you see on Law and Order. Those are courts of original jurisdiction, right? These are courts that originally hear the case. But it also created something called courts with appellate jurisdiction. And appellate jurisdiction is different. Original jurisdiction courts try the case itself, days, hours, weeks, even sometimes. But appellate jurisdiction courts do not try cases. Instead, right, they're not reviewing the factual record, they're not hearing testimony, they're not calling witnesses. Instead, they're looking at how the cases were resolved, or how the cases were decided in the original jurisdiction court. So they're only looking at legal issues. A couple of you hung back at the end of class last time and asked, if somebody disagreed with a court case, what can you do? And I essentially said, well, you can appeal the court, appeal the decision, but you can't appeal a decision and say, well, I disagree, they should have found me innocent, I'm appealing. That's not what an appeal is, right? An appeal is basically you are challenging the findings of the court of original jurisdiction by making the argument that it was wrongly decided, right? And so the appellate jurisdiction will hear the appeal, and the appeal is not saying, well, they reached the wrong conclusion. It might say something like, I was denied, legal representation, or with evidence was withheld against me, or I was not given proper time to launch a defense, or any of these number of different legal issues. You can make an appeal. And so once the original jurisdiction court reaches its decision, litigants, right, the defendant, can choose to appeal that decision, not on the basis of, again, not on the basis of disagreeing with the decision, but on the basis of saying legal issues were not properly followed. It also created legislative courts. So we have original jurisdiction courts, which is all of what you see on Law and Order, appellate jurisdiction courts, which are reviewing the factual record and basically seeing whether the original jurisdiction courts reached their decisions appropriately, and also legislative courts. These are much smaller and much less frequently used, but they are the courts of military appeals, court of international trade. These are very small, specialized courts within the federal government system that deal with very specific issues. And Now, to be very clear, right, when we talk about judicial review, this was created in Marbury v. Madison that we're going to look at, that basically said that the courts can have the power of saying whether something was constitutional or not constitutional, right? But these legislative courts, the Court of International Trade, the Court of Military Appeal, they lack the power to decide whether something was constitutional. They're simply looking at federal law and trying and applying it. Now, this is a pretty broad overview, not going into that great detail. We'll go into greater detail on the following slide when we start looking at the real meat and potatoes of the federal court system. Right? These are the questions the College Board tends to ask in the federal court system questions. So how is the federal court system structured? Now, well, I guess I'd never really mentioned this, but I did say, 98% of cases in this country are not charged in federal courts. They're charged at the state and pursued at state courts. But we're talking about the federal court system. Now, most federal litigation, so most federal criminal charges or civil lawsuits, they are going to begin in federal district courts. There are a couple hundred, not a couple hundred, what is there, I'll give you the exact number in a second, maybe 100 district courts in the country. There's 91, at least one district court in every state. And these district courts are courts of original jurisdiction, right? They're hearing cases related to federal law being violated. They are the ones that hear immigration cases. They're the ones that hear if the federal government is bringing charges against you for violating federal drug trafficking laws or sex trafficking laws or murder or any of these, they're going to try those cases because the district courts are courts of original jurisdiction. Now, within their jurisdiction is a vocabulary word for meaning like what do you have control over, right? So within their jurisdiction, they're charging or trying federal criminal trials. Remember, I said 98% of criminal trials are held in state courts. They're holding trials for civil suits that have violated federal law, right? So if you are suing the federal government for denying you, I don't know, denying you equal protection of the law or denying you voting rights or something like that, again, district courts will hear those civil suits. But they also are going to be the ones that try cases and civil suits when the litigants are from different states. So if I sue somebody in Kansas, then by definition, my suit crosses state lines. Therefore, my civil suit cannot be tried in a state court because if I sue somebody and I'm in Colorado and the other person's in Kansas, does my suit get tried in a Colorado state court or a Kansas state court? And because the litigants are from two different states, then all civil suits where the litigant, the plaintiff, and the defendant are from different states, those will be charged in or tried in district courts as well. Naturalization and immigration hearings, as I said, they also are going to be the one that review federal agency actions. So if I sue the EPA or if I sue the FAA or FCC or the INS, then the trial of original jurisdiction where the trial itself will be held will be in federal district courts. In Colorado, our closest district court is in Denver. And I believe that's the picture of it right up above. Now, district courts have their own staff, and you might have heard of some of these people in TV shows and movies. U.S. Marshals are basically the police force that supports federal district courts, serves warrants, picks people up who are being charged by the federal government and going to be tried by the federal government. They're also supported by U.S. attorneys. At the state level and local level, there is such thing as district attorneys. District attorneys are the ones who choose whether to try you for violating, Colorado state law or El Paso County law. But there are no district attorneys at the federal level. Instead, there are U.S. attorneys, and these U.S. attorneys are very powerful attorneys that are making decisions of whether or not the federal government is going to try or bring charges against a person. So, if when El Chapo was extradited to the United States for, federal drug trafficking violations, the U.S. attorney that was basically covering the southern U.S. border chose to bring charges against El Chapo. Now, U.S. attorneys, just like judges in federal courts, are nominated by the president to basically represent the federal government and make decisions on cases of whether or not to try. Now, these U.S. attorneys, again, are nominated by the president and approved by the Senate. Now, fundamentally, as we already said, right, courts of original jurisdiction try the trial, hold the trial, but a large number of their decisions that are settled in district courts, right, through a judge and a jury, a large number of their decisions do move on to federal appeal because the U.S. legal system makes appealing a decision relatively easy. Now, again, you can't launch an appeal by saying, well, I disagreed with the decision, but you can launch an appeal that said, again, I wasn't provided enough time, I wasn't provided adequate legal counsel, I wasn't, that I was denied the submission of certain evidence that I should have been allowed to submit. Basically, the legal system in the United States says as long as you're making a reasonable argument for grounds for appeal, it's generally going to be granted. Now, again, federal district courts are courts of original jurisdiction. So if you are appealing the district court decision, you're going to go to the next level. And we're going to take a look at this on the next slide. But this graphic is showing the organization of the federal court system. At the top, we obviously have the Supreme Court. Underneath the Supreme Court, we have the 12 circuit courts of appeal, which hold the appellate jurisdiction over the district courts. And then you have the Court of Appeals for the Federal Circuit. We'll talk about these down the line, but let's take a look at the next level, right? So district courts hold trials where the federal government has brought charges against you. The U.S. attorney has brought charges against you for violating federal law. Your trial will be in the U.S. District Court. But let's say you were found guilty in district court and you are launching an appeal based off of, your civil rights were violated in this trial and you were not provided adequate legal counsel. Okay, and so kind of continuing here, and I'm going to go back just to make sure we're not skipping anything because I had to stop here to finish something. We're picking up on the next part, which is after the U.S. District Courts stands the U.S. Court of Appeals. Now, as you can kind of guess from the name, the U.S. Court of Appeals is an appellate court. It's a court with appellate jurisdiction. They are empowered or tasked with the power to review the decisions of district courts, not to see whether the district court got to the right decision. That is not their job because they do not retry cases. Their job instead is to make sure that the decision of the district court was properly reached. There are 12 judicial circuits of appeals courts in the country. We'll look at a map on a future one, and you'll find where Colorado is. And typically, trials or hearings, as they would be called in the U.S. Court of Appeals, are only a couple hours long. They don't take days or weeks or months even, because there is no testimony. There's no witnesses called to the witness stand. There's no presentations well, there are presentations by lawyers, but essentially what there are arguments. Somebody representing the government's side of the case, and then usually the defense attorney, right? And what they do is they put forth their argument as to why their case or their decision was improperly reached at the lower district level. So, the judges that sit on the Court of Appeals, they just review the application of legal doctrine. They look at and say, well, this district court reached this conclusion based off this precedent, this precedent, and this precedent, but maybe they didn't consider this other thing, and they denied this person's right